the right-hand person to Jeffrey Epstein, who allegedly committed suicide in jail in 2019 to avoid being tried for sex trafficking crimes. She referred to herself as the lady of the Epstein household, and survivors claim that she not only groomed them and orchestrated their abuse, she participated in it. But grooming is not going to be a big part of this trial, the concept of grooming someone for abuse. And that's due to the fact that Judge Judith Nathan points to a lack of scientific literature to support, in this case, what would be known as grooming by proxy, meaning someone who is grooming victims on behalf of someone else. So if Judge Nathan wanted to, could Judge Nathan allow the prosecution to explore this area of grooming, even without a large amount of scientific evidence or literature to support it? Is there a legal standard that the judge is following here, or is this just her personal feeling and judgment?
Expert witnesses. So you would bring somebody in who maybe a psychologist, typically you would bring in to talk about how grooming works, what research has been done related to grooming, what there are papers published in journals related to grooming, any of the study thereof. But it really depends on expert witnesses. It depends on previous case law and the judge's discretion. As we've talked about so many times here on the Law Junkie Show, is judges, with very limited exception, have great discretion in their own courtroom about what they allow and what they don't allow as testimony for the jury to hear. Most importantly, there are two primary factors. Is it a probative value, meaning does it present facts that are relative to the core issue at hand? So that's the probative, yes or no. And part two is it prejudicial against the defendant in the eyes of the jury? So even if something is probative, if it's going to be prejudicial and damage the defendant in a way that is going to be problematic, then the judge is going to rule against that as well. And then there are dozens and dozens, if not hundreds of other rules and sub-rules after that. But those are the two primary factors that a judge considers.
Well, if I'm not mistaken, in this case, she does say that there's a lack of scientific literature. And I think those may have been her exact words. So what is the legal standard regarding scientific literature that she's referring to?
So the answer regarding specifically to scientific, technical, or other specialized knowledge is actually called the Daubert test, or Daubert. I don't know if I've ever heard it called that, but I pronounce it Daubert. It's Federal Rules of Evidence number 702. And I quote, "If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise." So the Supreme Court has, in the Daubert case, specifically held that Rule 702 applies to all scientific evidence rather than only to novel evidence from the prior Fry standard. So really, the judge just basically says, yes, the expert witness can come in if there's new knowledge, and then the defense can challenge it. So they can bring it in on the presentation, and the defense can challenge it. Well, and if it's allowed in, could come up in an appeal. Likely, it will come up on appeal.
All right, Maxwell's team is using the empty chair defense. They're saying that they really want Jeffrey Epstein, but he's not here. He's dead, so you'll do. And that seems weak and thin, even, just from an outsider's point of view. Has this defense ever worked?
Well, the empty chair defense, it means that you're blaming somebody that's not in court. That's often used in things like personal injury cases. Somebody else is responsible for what happened to the plaintiff. Is that going to work in this case? I don't see that it's a strong defense to just blame, well, if this is all on Jeffrey Epstein, my poor client had nothing to do with it. This is Epstein's fault. I just don't see how that's going to hold.
She was in such close proximity with him on so many levels. Wouldn't she have been brought up on her own charges anyway had his proceedings continued?
Yes,
likely.
it's important to note that if he had been found not guilty on all counts, it's a much more difficult case against Ghislaine Maxwell. So if, this really does come down to the fact that you're going to blame Jeffrey Epstein for everything, but it's hypothetical what would have happened in his case. We don't know how that case would have turned out. The jury needs to listen to the evidence that's put in front of them and make their decision. I just don't think the empty chair is going to be a good one in this case.
They've also tried to use Epstein's non-prosecution agreement. How would that have ever protected her unless she was specifically named in it, or was she?
Well, Epstein's non-prosecution agreement, which I do believe was a miscarriage of justice, that is my opinion, not a legal conclusion, but a personal opinion. Upon reading it, which is available on the internet, it does not name Ghislaine Maxwell. It is an agreement that Epstein made. It's essentially a plea agreement. It's broad-ranging in terms of he's protected. It's this nominal charge. He has to register as a sex offender. But basically everything's dropped, and it's a nominal charge that he's admitting to at that time. And it's just shocking. It's hard to read. I don't know how else to say it. It is hard to read. And, but it does not absolve Ghislaine Maxwell. It does not cover her. At least the way I read it, I didn't see anything in here that does. I could have missed something, but at least on my reading of it, I don't see that she's protected.
And that's the one that Alan Dershowitz signed off on, right? Wasn't that his?
Well, let me look at the signatures on here. I see U.S. Assistant Attorney. I see a counsel, 2 attorneys for Epstein and Epstein himself. I do not see Alan Dershowitz's name on this document.
Okay. So he didn't really have anything to do with that?
Well, that doesn't mean that. He could have been an attorney behind the scenes. He could have been negotiating it with the U.S. Attorney's Office. But it was Epstein's attorneys who signed it. Gerald Lefcourt and Lily Ann Sanchez are the signatories.
The defense is also using what a lot of people would call dirty tricks. If you've seen a movie where the defense is meant to be portrayed as evil, like ruthless and evil, this would be that defense. For example, they say that the survivors are doing this for money. They say that the survivors are just making things up. They're bringing in an expert on false memories. And they've even attacked the first witness, going anonymously by the name Jane to protect her identity because she's currently a working actress. You're an actress, right? So obviously you're great at lying and faking emotion is their actual approach, which is not only completely ignorant and insulting to the craft of acting, but it's cruel.
Yeah, so this is the defense doing their job. As long as the judge is not ruling against them for being out of order or for being prejudicial in front of the jury toward, their job, let me step back. The job of the defense attorney here is to provide a vigorous defense of Ms. Maxwell. And while to the public and to most of us, we look at Ghislaine Maxwell and go, guilty, I don't like her, she was horrible, all of these things, the defense attorney, everybody in the United States under the Sixth Amendment has a right to a defense.
But do you think this plays well with jurors? Do you think that this could possibly actually work against them?
It's really hard to know. New York in federal court has a fairly educated jury pool, but it's a very diverse jury pool in New York. And so it's hard to know exactly which jurors they selected and to understand them from this position, because this being in federal court, we don't have live audio, we don't have live video. We're getting the snippets of quotes out of court, a little bit like Elizabeth Holmes, where we just don't have that level of visibility, unlike some of the other big cases that have been in the public eye recently, which were in state courts where there was video and audio. Here, it's really hard to know how the jury is responding. But I will say that, look, her job, this defense attorney, is to introduce doubt about the witness, and the term is impeachment, meaning make them a less reliable person that the jury should not trust as much when they go back and do their deliberations regarding what Jane, who I believe was 14 at the time of the alleged crimes, what happened to Jane that many years ago. So they're doing their job.
Okay, so the defense also accidentally revealed Jane's surname, which she was trying very hard to protect. They also leaked the names of a couple of her siblings. Do you think they may have done this on purpose to try to intimidate future witnesses or scare them? The judge admonished them and they were reprimanded, but it's kind of like it already happened. She said not to do it again, but if you're a witness paying attention, you already know that happened. It may have already served its purpose, even if you got your warning from the judge. And for example, if they were actually intimidated and decided they did not want to take the stand, would they then just be subpoenaed?
No. So, yes, they could be subpoenaed, but if the judge has already admonished the defense for doing this, that's actually kind of a big deal. So the next step after an admonishment is, and the judge possibly threatens sanctions. So attorneys will push boundaries, again, in their zealous advocacy of their client. And if a judge admonishes, the judge will often say, and if you do it again, we're going to look at sanctions to the counsel. So nobody wants to have a sanction. That's just, no attorney wants to be sanctioned. So they're pushing the boundary. If the prosecution, for example, thought that amounted to witness intimidation, they would have requested sanctions in the moment of the judge. They would have actually requested that. And further, the prosecution does have the ability to call for a mistrial. If they believe it was bad enough that it actually caused prejudice with the jury and or scared the witnesses to the point that they're no longer going to testify, they're not going to be able to continue testifying, they could call for a mistrial as well.
The defense complained to the judge that the request to protect the witnesses' anonymity was overly broad and unworkable. Is it really that hard for them? Is that really that hard?
So it isn't. That is a maneuver. Again, every attorney is supposed to use whatever tools are available to serve the client. So in this case, if they felt that using an anonymous name in court, when it's possible this witness is no longer under physical threat, that's where it's most often used, would be, let's just, for the sake of conversation, a mob prosecution, gang prosecution. The person's life is truly in danger for testifying against the defendant. Here, I can see the argument that maybe Jane's life is not in danger for testifying against Ghislaine Maxwell. On the other hand, I would argue that her life is in danger for testifying against Ghislaine Maxwell when you look at the names of some of the world's wealthiest and most powerful people getting caught up in the whole Epstein story. And maybe not directly in this trial, they're on the periphery looking in. So, look, the defense will ask for it. They didn't get it. And that's it. That's it for the defense. They did their job, though.
And speaking of powerful people, one of the prosecutors is Maureen Comey, who you may know, her father, James Comey. A former attorney general. He's a powerful figure. Interestingly, Maureen is in the Southern District of New York office as a prosecutor. When Jeffrey Epstein was in jail the night that he took his own life, allegedly. He was first locked in a room, in a cell, with a police officer accused of a triple homicide. Maureen Comey was also his prosecutor. Jeffrey Epstein's attorney, claimed that the marks around Jeffrey Epstein's neck were due to this police officer trying to rough up Jeffrey Epstein. And the police officer claimed he was trying to prevent Jeffrey Epstein from committing suicide. So, how is Maureen Comey so fortunate as to land all these high-profile cases? And for people who love to go to conspiracy theories immediately with this, and it's hard not to in this case, I mean, just because of all of the high-profile names, the four witnesses who are the victims, the survivors in this case with Jeffrey Epstein, it doesn't look like any of them are associated with any of these high-profile people, the only one being Ghislaine and Jeffrey Epstein, who is dead, whereas there are other names that could have been called that have directly been connected to, for example, Prince Andrew, Alan Dershowitz, Bill Richardson, etc.
I believe Donald Trump was specifically named in this, wasn't he? No, I mean by one of the witnesses.
Yes, but only briefly. That
Okay.
It was acknowledged that he was seen on a plane.
No, they went to Mar-a-Lago.
Right, but he wasn't accused of anything. Nothing improper.
No,
Accused
right.
of
I
nothing.
agree.
Yeah.
I agree. But in terms of when your name is brought up in a trial like this, nobody wants their name brought up in a trial like this, right? I mean, nobody would.
Right, but it would be very different to have your name just mentioned that you were someplace as opposed to that you were actually an abuser yourself.
So is your question about Ms. Comey?
Well, yeah, that's the original question. Is in one of these cases where this one in particular, where there just is so much conspiracy theory, people want to go there. Wouldn't whoever is making the decision to assign these cases, aren't there so many other prosecutors who could have taken this case? And why add any fuel to possible conspiracy theories?
So that's complicated. And let me give I want to start by prefacing by saying I have not worked in a U.S. attorney's office. So this is me speculating based on conversations with people who have worked in U.S. attorneys' offices, okay? They are no different than big law firms in terms, and big companies or any kind of corporate job that anybody has kind of anywhere in the world. Things are political. So there are kind of the chosen select few who are the stars, and Ms. Comey is, if it's Ms., it could be Mrs., I don't know. So I'll just say Ms. in the generic sense. Ms. Comey is clearly a rising star in the Southern District of New York. It is the U.S. attorney who makes that final, especially on high-profile cases like this. That is, the U.S. attorney at the time will choose that. I believe it was Mr. Bearman when this case started. And he, in that case, would have selected her to lead the prosecution against Ghislaine Maxwell, including leading the prosecution against that police officer. And when somebody is doing well in their prosecutions, they continue working their way up. And if they're not doing well, then they're not necessarily a chosen star. So what this indicates is whether or not her name means something, which I don't know how it doesn't, but let's just assume it doesn't. It means she's doing a great job. And the U.S. attorneys at SDNY are recognizing that and saying, we need you to be the lead on this. We need you in court arguing it because you're the one who's going to bring it home for us and get the conviction like we need to do, especially on a huge case like this. There's so much riding on it, so much attention. This is such a big deal and affects so many people in the world, for that matter. I mean, we've already named the rich and powerful involved, allegedly, in this case. And so that just speaks to her. Maybe she could be another FBI director in the future and follow in her dad's footsteps. I don't know otherwise.
Maxwell's been complaining about the conditions of her jail cell from the beginning, about everything about it, which what she describes sounds typical to prison life. And she's
who enjoys it, by the way.
Right. It's, guards are shining lights in my faces and in my face. And yeah, that sounds about right. So, yeah, but she's complained about not getting enough food and sleep on days that she has to be transported to court, and that she hasn't been getting her mail, different things. So Judge Nathan's response has been very consistently like, yeah, well, you're getting treated like everyone else. This is the protocol. This is the standard. This is the norm. And you are no different, and you will be treated the same. And let's just say, for kind of fun, what if the judge wanted to show preferential treatment to her? How much kind of room would a judge have? Could a judge actually say, oh, I feel terrible for you. We'll have a car pick you up every day instead of a van that's a prison van, and you'll be able to stop by your favorite restaurant. Can judges do things like that?
The judge does not have control over the transportation between where she's being held and the courthouse. That is not the judge's purview. There are other rules that govern that.
Can they make it their purview?
I don't believe so. I have to think about that for a second. I don't believe so. I really don't. What the judge can do, though, as we have seen in other high-profile instances happening in Washington, D.C., for example, or not in D.C., but coming out of Washington, D.C., is judges can grant things like, oh, you can go home for the weekend. You can go on a vacation. You can go hunting. You can go do things. Judges can grant releases from prison. But in terms of the transportation between, I believe there are other, I don't know the exact other bodies involved. I don't know if it's Bureau of Prisons, the FBI itself, maybe the Marshals Service regarding the transportation of a high-profile individual like this between prison and court. But there really would be limits on that portion of it that the judge could do.
Okay. Well, thank you. And thank you for listening to Law Junkie Show. Follow us on social media. Send us a message at info@lawjunkieshow.com. Visit us at lawjunkieshow.com and send us a message on the contact form there. Follow us on YouTube, Apple Podcasts. Leave us a review if you like this show. And we'll see you next time.
Disclaimer. Law Junkie Show, including its guests and hosts, are not giving out legal advice, but discussing general legal issues. Law Junkie Show does not guarantee that the legal issues discussed are fully accurate, and it's not specific to whatever legal issues you may be experiencing. None of this advice is to be acted upon in your situation. Please seek legal advice from a licensed attorney in your jurisdiction for your individual legal matter.